Welcome to the Legal Implications of Cannabis Module, Section 2, Legal Considerations for Patients and Practitioners. There are several legal and financial implications patients should consider prior to initiating cannabis therapy. First, employment. State unfair employment practice laws generally find it unlawful to prohibit legal activities as a condition of employment. But because cannabis is illegal under federal law, it can be legally prohibited by an employer. In 2015, the Supreme Court ruling in Coates v. Dish Network upheld that an employer can fire an employee for off-the-clock use of cannabis in a state with legal recreational cannabis laws. Patients should be instructed to check with their Human Resources Department to determine if medical cannabis use is accepted by their employer prior to initiating therapy. Secondly, housing. Section 8 or other federal housing aid recipients are not allowed to use cannabis regardless of the legal status within the state. Additionally, renters can be evicted for cannabis use if their lease prohibits illicit drugs, even if their cannabis use is compliant with state law. Thirdly, taxes. Internal Revenue Service Code Section 280E prohibits cannabis businesses from deducting ordinary business expenses such as marketing, training, or transportation, which leads to higher patient product costs to cover these expenses. Also, money patients spend on medical cannabis is not tax deductible and cannot be reimbursed. Finally, insurance. Due to the federal illegal status of cannabis, it is not covered by insurance and cannot be reimbursed through an FSA or HSA account. However, it is important to note that patients are not at risk of losing their Medicare, Medicaid, or veterans benefits if they go outside of their plan to obtain medical cannabis through a legal state system. Patients using medical cannabis may also lose their right to bear arms, as there is a federal ban on the sale of guns to users of illegal substances. This was upheld by the Ninth Circuit Court of Appeals, who maintained that drug use, quote, raises the risk of irrational or unpredictable behavior with which gun use should not be associated, unquote, even if obtained legally for medical purposes. Finally, hospitalization is a large issue for users of medical cannabis because patients using medical cannabis cannot receive their medication from the hospital when they are admitted. This creates a risk for patients as they are unable to receive their medication and may experience a relapse of symptoms without their cannabis therapy. It also creates a risk for practitioners who cannot legally provide or administer a federally illegal substance to a patient on hospital grounds. However, many hospitals are now simply turning a blind eye and allowing patients to bring their cannabis medication into the hospital, provided it is not in smokable form and they are able to self-administer or have a designated caregiver who is able to administer the medication. Due to the fact that cannabis remains federally illegal, cannabis medication cannot be legally transported across state lines. This means that patients traveling outside of their home state cannot legally bring their medication with them, and most states do not allow for non-residents to purchase medical cannabis outside their home state, although there are a few exceptions. This poses major accessibility issues for patients traveling outside their home state for business and leisure purposes. Patients should always be instructed that they are at risk for prosecution if caught transporting medical cannabis products across state lines. There are also several legal implications to consider for practitioners. The first is malpractice. Thus far, no malpractice suits have been filed against practitioners practicing cannabis medicine. These suits would be largely unenforceable because practitioners are only recommending use. They are not prescribing the medication. Also, medical cannabis use is primarily patient-driven, which means that patients are seeking out the therapy themselves and are unlikely to sue for malpractice. Practitioners should also be aware they may be putting their hospital affiliation at risk if they choose to pursue recommendations for medical cannabis to their patients. Any hospital, nursing home, or community health center that participates with Medicaid or Medicare is required to sign an agreement stating they will comply with all federal laws. For this reason, it is in the practitioner's best interest to ensure that incorporating medical cannabis into their practice will not jeopardize the relationship with any facilities they currently work with. Finally, because cannabis is a federally illegal substance, practitioners who recommend it may be at risk to a DEA investigation and possible loss of license. This has only occurred in cases of gross negligence in legal medical states, but practitioners should always be aware of the potential risk. Following these best practices can significantly reduce the legal risk of practitioners. First, the practitioner should physically examine the patient. There has been a case of a physician license being revoked for issuing a cannabis certification to a 28-week pregnant woman who was not physically examined. Many states do allow telemedicine visits for cannabis recommendation. In these cases, patient history and record keeping is especially important in absence of an in-person examination. Secondly, the full medical history of the patient should always be obtained, including a review of past medical treatments. Third, patient follow-up and continuing oversight should always be part of the overall treatment plan when recommending medical cannabis. Fourth, practitioners should not dispense cannabis directly to the patient. It should only come from a licensed dispensary. Various other regulations apply on a state-by-state basis. For example, some states require the physician to have an established relationship with the patient. Also, some states allow allied health professionals to recommend cannabis, and some do not. By paying attention to your specific state regulations, you can reduce your legal risk by following these best practices. It is very important for practitioners to keep accurate patient charts, which include cannabis use. Documentation is key, and notes should include decision rationale, discussion of risk, and alternative therapies discussed. Practitioners should also consider using a written disclosure or treatment agreement form to be signed by the patient, which covers addiction potential, side effects, a waiver of risk associated with cannabis use, and that the recommendation is being issued upon reliance of the patient's statement of symptoms and diagnosis. This written treatment agreement can help mitigate the risk of the practitioner and protect them against legal action. It is important for practitioners to ensure that the malpractice insurance coverage they carry covers the recommendation of medical cannabis and/or does not explicitly exclude it from coverage. This has become a growing issue as not all malpractice insurances will insure practitioners recommending medical cannabis. Practitioners should also maintain a professional boundary from dispensaries. Practitioners recommending cannabis should not be directly affiliated with a cannabis dispensary, as this represents a conflict of interest and can put practitioner integrity into question. It bears repeating that cannabis regulations vary widely from state to state, so it is important to be aware of the cannabis program regulations specific to the state in which you are practicing to ensure you are in legal compliance. In summary, despite the widespread legalization of cannabis on a state level, it remains a federally illegal substance, which creates a risk for both practitioners and patients. Several federal amendments and rulings exist against the use of federal funds for the purpose of prosecuting against cannabis providers and patients who are complying with state law, providing patients and practitioners some level of legal protection. Patients and recreational cannabis users should be made aware of the risks of use prior to initiating treatment in a legal or medical cannabis program. Practitioners should always follow best practices in order to ensure they have adequate protection against legal action. This concludes the Legal Implications Learning module. Thank you for joining us.